next case is in re estate of John B. Markling Jr. Each party will have up to 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, please let me know so I'll keep track of the time. The arguments are being recorded, so please keep your voices up and remain behind the podium. You should not use the names of children or minors or victims should that be relevant to your presentation. The judges have read your briefs and are ready to proceed when you are, and I would just ask appellant at this time, would you like to reserve time for rebuttal?
I'd like to reserve 5 minutes, Your Honor.
Very well, then you may proceed, and please introduce yourselves also.
May it please the court, my name is Matthew John Markling with McGowan & Markling, and I represent the appellants. We respectfully request that this honorable court reverse the October 12, 2022 judgment of the trial court dismissing the case and granting the memorandum of understanding, reverse the June 24, 2022 order denying the motion to dismiss, and third, dismiss the amended complaint as to all appellants. This is a case about the record. It's about what is improperly in the record, what's properly in the record, and what's missing from the record. I would like to begin by discussing the memorandum of understanding and the order granting the same. That memorandum of understanding was improperly submitted by the appellee to the trial court. It was a confidential memorandum. There was no authorization by the appellants to submit that document to the trial court. And the trial court rules prohibit such documents from being submitted to the court, absent agreement by the other side. Not only did appellee improperly submit the court to the MOU to the trial court, it remains unclear even on remand as to how the document ended up in the trial court's hands.
Counsel, just so I can understand a little bit more, was there an objection or opposition to the appellee's motion on filing the memorandum of understanding with the trial court?
There was not in the record.
Okay. Was there a challenge to the contents of the memorandum of understanding?
Yes.
Okay, and what form did that come in?
So through several ways, Your Honor. One, through legal counsel, between legal counsel, part of the memorandum of understanding.
In the record, we're going to find this?
You're not. Because, well, actually you will see the record. You will see that after the trial court granted adopted the memorandum of understanding, you will see that there was a request from the appellants to have an evidentiary hearing to consider the settlement agreements and the lack thereof and the communication going back and forth.
I have a question. So
Yes, Your Honor.
The parties ordered a mediation.
Yes, Your Honor.
Was the memo of understanding, which isn't attached because it's not incorporated in the journal entry, and that's an issue you have, and it's confidential. Was that stemming from the mediation?
Yes.
Was it signed by both parties?
Yes.
Is it
Partially.
Is it possible the mediator gave that to the court? Because when there's a settlement, the mediator gives the settlement agreement to the court?
Well, it is, I suppose anything is possible. There is, to Judge Sutton's question or comment, there is a argument in the record that there, along with the peculiarities of this, the mediator actually had the judge's personal file and had the judge's notes and was reading the judge's notes and should not have been submitting a report to the court at all. What was properly submitted by the mediator, that's in the record, is a standard report that the case went to mediation and the case was settled. And that was properly submitted, it is in the record. It appears that when document 150, Your Honor, it's being referred to, was submitted, it should have gone through the process of being filed under seal, to the extent there was even permission to file it. It appears that what happened, it was hand-delivered to the judge by counsel for appellee. The judge sat on it until the judge approved the order that was prepared by counsel for appellee and even signed by counsel for appellee. And on the last page of the order, on the second line of the second page, says that the court has reviewed the memorandum of understanding and adopts it. I do not know, Your Honor, how that memorandum of understanding ever got in front of the court, because part of the analysis today is what's not in the record. And there isn't any evidence as to how it was in the record. Your Honor, on remand, this court ordered that the trial court clarify the record, to clarify what was in, what 150 is, document 150, and how document 150 came to be before the court. The trial court did part of that. The trial court stated that the document was the memorandum of understanding, but did not state how the document got in front of the trial court.
Counsel, did you file at any time a request in the trial court to view the document in camera, or?
Yes,
You did. Okay, and will I find that in the record then?
you will. You will see that there was, right after the October 12, 2022 decision granting the memorandum of understanding, there was a motion for an evidentiary hearing to see, to go over, all those issues. When it became clear that there was unclarity as to what was document 150, you will also see.
Counsel, I'm sorry, I don't mean to interrupt you, but I still am a little bit unclear, to use your term. You did sign a memorandum of understanding, correct?
Partially, half of the memorandum of
Explain to
understanding.
me what you mean by that, because you mentioned that earlier.
So-
Partially signed, what does that mean?
So there was the memorandum of
And
understanding.
what I'm gonna find in the record, obviously.
Well, you will see document 150, assuming it's in the record, and you will see that it is just a bullet points. And then you will see that it was signed by the appellants, and you will also see that after mediation and the appellants left, counsel for the appellants and for the appellee engaged in further mediation discussions that were signed without the approval of the appellants. And that's noted, Your Honor, on the bottom of the memorandum of understanding.
Was there a notice of satisfaction regarding the memorandum of understanding that was also filed?
Yes, on behalf of the appellants had one obligation. The appellant's obligation was to transfer funds. Well, appellants had two obligations. One was to transfer funds into an escrow account, and the second obligation was to enter into a settlement agreement that memorialized the terms of the settlement.
So is it your argument that, I'm trying to understand, that the memorandum of understanding that was document 150 was not, like, part of that, the part that you say part of it was unauthorized, so on behalf of the client?
That is true. However, I don't want the court to go down a false flag. That's not the terms of the general terms of the memorandum of understanding were agreed upon, and then there needed to be a settlement agreement to memorialize it. And what wasn't presented to the trial court is the fact that those terms were refused to be agreed upon by the appellee. And in fact, the terms that were insisted upon appellee are illegal. One of the terms is a confidentiality provision, and through the settlement process, the appellee and counsel for appellee were arguing a provision that is against the Code of Professional Conduct, and that is that the appellants need to not assist law enforcement. There's a pending matter before law enforcement as to appellee's theft. And one of the terms that you'll see in the memorandum of understanding, which appears to be a non-confidentiality, or a confidentiality provision and a non-disparagement provision, which appellants have no problem with, other than when insisting on the settlement agreement, the assistance was that law enforcement cannot be advised as to the outcome and the appellants cannot assist law enforcement. Now, you're not going to see that in the record because appellants attempted to submit those settlement documents, and this honorable court has already ruled in such situations there should be an evidentiary hearing, of which there was not. They could have explained that, one, that provision is illegal, to the extent that's what appellee was looking to enforce. But I want to be clear, Judge Sutton, that the intent set forth in that memorandum of understanding, there is no objection that that in consideration of the representations that the real property was maintained, in consideration of the representations that personal property of the trust would be returned, and a dismissal of all claims.
Counsel, I want to let you know that you are moving into your rebuttal time.
And then a dismissal of all claims and the execution of the settlement agreement would have resulted in a sufficient settlement agreement and would have been dismissed and there would have been no issue. What happened is, in this case, is that rather than continue the mediation process or continue the settlement process or to go back to a mediator, unilaterally appellees handed a judgment entry and a memorandum of understanding that never should have been in front of the court because those terms have not been satisfied by the appellee. And there's no evidence in the record that has been satisfied by the appellee. So there was another avenue, a proper avenue, that should have been done. What should have been done is if the appellee felt that the memorandum of understanding wasn't being satisfied, then they should have requested a hearing. They should have submitted, go back to mediation. They should have asserted a breach. There were many avenues that they could have properly gone before the trial court. But for whatever reason, the appellee drafted a judgment entry that dismissed the case and adopted a memorandum of understanding, which is wholly improper. Now, Judge Sutton, as you notice, I'm running out of time, but I'm confident that the arguments have been set forth in the briefing. I know that I have reserved time and I've got 3 minutes going, but do you have any questions, any further questions for me before I sit down?
Hearing none at this time, you will have about 3 minutes for rebuttal.
Thank you, Your Honor.
Yep.
May it please the court, my name is attorney Lee Groskup, and I'm here on behalf of Vicki Geis, now married and known as Vicki Sabork. The trial court in this case committed no abuse of discretion adopting the August 9th memorandum of understanding as an order of the court. Now, said in another way, the court did not make an unconscionable, unreasonable, or arbitrary decision in this case. On September 27th, 2022, appellee filed a motion to adopt the memorandum of understanding, and after 14 days, appellants made no response whatsoever. They did not contest the terms of the memorandum of understanding, which in this case there is only one single page paper that's signed by the parties. This is not multiple drafts signed by the parties. We're talking one on August 9th, 2022 that's been signed. There's been no contest. There was no response regarding the existence of a settlement agreement. There was no response contesting the terms of the agreement. And according to the law, the law says that the trial court can move forward and adopt the agreement of the parties if no challenge is made without holding an evidentiary hearing. And it goes on to say that in Teague versus Schmelzer, it's also an abuse of discretion on whether to conduct an evidentiary hearing. Well, in this case, there was nothing in dispute, nothing was raised until after the fact. And that's what this case is all about, is after the fact, the appellant, the trustee in this case, does not want to follow through with the agreement, which is, the trial court has now made, it's not confidential anymore, based upon on remand. The trial court said that it's not confidential. The trustee will not fulfill his end of the bargain. His end of the bargain is to pay X amount to Mrs. Saborik, and he will not do it. Mrs. Saborik, on August 15th, just mere days after the parties reached the agreement, she moved out of the residence that is held in trust. Mrs. Saborik was granted a 1/6 beneficiary of the trust residue, which was a considerable amount of money in the pot at the time, which we have a good faith belief outside of the record that it's been dwindled down. She had the opportunity to live in this.
Stay within the record.
She had the opportunity to reside in the residence for 5 years rent-free. So as we sit here, this is about a 1-year anniversary of Mrs. Saborik living up to her end of the bargain and moving out of the house, and the trustee unfortunately not complying with his end of the bargain. Which brings us to why this appeal was ultimately filed by the trustee. The trustee filed this appeal to delay the contempt action that's currently pending in the trial court. This matter should be remanded down. The assignments of error should be rejected, which the bulk of the brief, what was briefed here today, was assignment of error number 1, which was a regurgitation of the motion to dismiss that was denied by the trial court. But in oral argument, that wasn't even argued before the court. The assignment of error number 2 contained 1 page. There was no legal authority in regards to adopting a settlement agreement as an order of the court. There was no facts provided in the brief. So we come today before the court with an oral argument that Mrs. Saborik has had to form her own legal argument in this case because there has been nothing presented in appellant's brief regarding the issues that appellant argues here today. So we believe, with a good faith belief, that this is a frivolous appeal, that this appeal was filed, a sophisticated attempt to delay what is the parties' agreement, is fulfilling the other side of the bargain. And this was filed to delay that process. Because if you look in docket number 158, the affidavit that Mrs. Saborik signed, it also contains a considerable amount of correspondence. All of the written correspondence from after the mediation up until November 4th, when the trustee filed the appeal for the first time. And the very last, while Colleen O'Neill was representing the trustee, the last correspondence sent to the other side was, you need to live up to your end of the bargain or we're going to take you back to court. Well, that day, immediately after that correspondence, the appellant, the trustee, filed this notice of appeal in an attempt to prevent fulfilling his end of the bargain. So there's 2 avenues that this court can award attorney fees in this case, which is unique on this appeal. So Revised Code 5810.04 allows this court, as a judicial proceeding, in justice and equity, this court has the opportunity to order attorney fees in this case paid. And justice and equity certainly apply in this case. Dating back over 3 years, it all boils down to the one sentence that Mr. Markling stated to Mrs. Saborik on December 31st, that he's going to bury her in court, along with other expletives that were involved. We have an affidavit that supports that statement being made, and he has lived up to his end of the bargain. That's the only end of the bargain that he has lived up to in this case. Now, justice and equity require that attorney fees be paid because Mr. Markling is an attorney. He is running this trust currently. And there is no end in sight until a court stops the trustee and enforces the trustee to do what's in the best interest of the trust. There are 6 grandchildren involved in this case, 3 of which are being represented by their father, who have a unique interest separate from their father. This is not a person A versus person B. This is a trust, and the representative of the trust, using the full force and power of the knowledge and expertise of being an attorney and having a law firm, and using the power of the trust and the resources at the disposal to go against one beneficiary. And that action taken by the trustee in this case for going on 3 years, has not been in the best interest of Mrs. Saborik, it's not been in the best interest of the trust, and justice and equity require that Mrs. Saborik be reimbursed for her attorney fees just for the trustee to live up to his end of the bargain. We also believe that under Appellate Rule 23 that this is a frivolous appeal. It's spurious. From docket number 158, the communications that were sent back and forth, it's clear that there was significant struggle on the other side in order for what the parties agreed to be completed. The only issue that still needed to be resolved, if you look at the memorandum of understanding, is the parties further agreed for non-disparagement, confidentiality, and mutual release clauses. That is all that was waited on, that we were waiting for, which that never came. The parties agreed for the settlement amount to be held in Calfee's escrow account. It's not. After Mrs. Geis, or after Mrs. Saborik moved out of the house, she asked to return the keys to counsel for the trustee. That was ignored. That was even refused. So we come before this court asking the court to deny the 3 assignments. Well, for us, the 2 assignments of error. There was a 3rd assignment of error regarding the first counsel that represented Mr. Markling. We have no say on that, but for the first 2 assignments of error, we ask that it be denied. We ask that the court issue an order for Mrs. Saborik's attorney fees in the amount of $14,000 to be paid by Mr. Markling. And in the alternative, we ask that the court remand this and preserve the issue to allow the trial court to, along with the motion contempt that is currently waiting, for the trial court to rule on the attorney fees that were part of this process. If there's any further questions, I'd be happy to.
Hearing none, thank you very much for your presentation. Mr. Markling, you will have 3 minutes for your rebuttal.
Thank you, Your Honor. I'm going to make it, I have some points, but I want to highlight the most important one, which is an admission from counsel that there were remaining outstanding items that needed to be resolved to perform on the MOU. And one of those is a very important one, which is the agreement of a mutual release, of which the appellee would not agree to a mutual release. And there's no evidence in the record because the trial court didn't hold an evidentiary hearing. What was also stated in an admission in another piece of the memorandum of understanding that was not fully performed to bring it all to a conclusion was the non-disparagement clause, because appellee was insisting on a provision that is illegal, that attorneys cannot agree to make criminal actions pending on a settlement agreement. The statement, there was also a statement made which counsel is correct. This case is an odd case because the record takes a life of its own. This court remanded the matter to the trial court for the sole purpose of, for the trial court identifying what Record 150 is. The trial court, for whatever reason, on its own, again in violation of the rules and the law, did make Document 150 public. The trial court unilaterally, on her own, declared that the confidential memorandum of understanding was now a public record. That was not what was on remand, and yet that is what she did. The evidence. Judge Sutton, I appreciate reminding about what's in the record, because what is argued throughout this case are things that are not in the record. There are the facts that were submitted to you. There's no affidavit from the appellee testifying to any of the allegations that are made. To the contrary, there are hearsay statements from other people, but what you will notice is there is nothing in the record. The first affidavit or verified statement from the appellee in this case is document 158. Document 158 is additional evidence that demonstrates that there clearly wasn't a meeting of the minds because the attorneys were going back and forth trying to finalize the settlement agreement. And the appellee has already admitted that that memorandum of understanding was not performed to its fullest because there wasn't a mutual release agreed upon, and there was a non-disparagement provision that was illegal that the parties couldn't agree to. The record is clear. This is what is clear in the record. And to Judge Sutton's question earlier, the appellant's obligation was to submit money in an account, an escrow account. That was done.
And Counselor, you're gonna have to wrap up.
I'm done, Your Honor. Unless there's any further questions. I see my time is. Okay,
Well,
thank you. Thank you.
Thank you both for your presentations. The court will take the matter under advisement and issue a decision in due course. A copy of that decision will be mailed to you on the day that it is released, and it will also be posted on the Ohio Supreme Court website. Thank you again very much.